talk about both of these cases is Damian Jackson. He is a partner at the law firm of Reilly, McDevitt and Henrich. He specializes in the defense of complex litigation cases and has served as lead counsel for more than 100 jury trials, both criminal and civil. So, Damian, thank you so much for being with us this afternoon. Now, we know that jurors, again, are in the midst of day 2 of deliberations in the Rittenhouse case. We know that before the 12-member jury was selected, ultimately, Rittenhouse himself was able to draw the numbers of 6 jurors out of a raffle drum type of a setting. Those jurors are now serving as alternates. Now, the judge said he has allowed this practice for years, but the optics there seemed odd for many people watching this trial. So, Damian, is that the norm, and what were your thoughts when you saw that?
Oh, it is ridiculously abnormal. I have never seen a judge allow a defendant to pick the alternates in that way. Normally, the fashion, the protocol would be for somebody, his court staff, as you see there, to pick the numbers. For him to do that, there's no rule against it, but it's definitely bad optics. It, in my mind, gives the jury the idea that, hey, this guy might not be that bad. The judge is letting him interact with his tip staff, which are the court officers, and really personalizing him unfairly.
So, yeah, so the optics there, you think, were definitely a bit jarring. So we also know that the judge dropped a misdemeanor weapons possession charge against Rittenhouse as well. Is that something that you see often in a case where the defendant is facing multiple charges? This happened just before the jury deliberated.
Yes, the judge wants to send the jury back with the most clean job that they can have. And that misdemeanor charge was just a throw-in at the end. The real case is him assaulting these other individuals. That weapons charge, I believe, looking at the statute out there, would have been a fine at most. And that really wouldn't have served any purpose in this case.
Okay, and another high-profile case that we're following very closely as well, playing out nationally, is the killing of Ahmaud Arbery. As we just saw, the defense put defendant Travis McMichael on the stand. In his own defense, he fatally shot Arbery. What is the risk, though, of putting the defendant on the stand? And is that good for the defense's case, possibly, or could it hurt it?
Whenever you put a defendant on the stand like that, that means you have nothing else. You have to go all in. All we have you're throwing a bomb. All you have at this point. I think it's bad in this situation because obviously the facts state that they chased this man down. Now, if they want to try and say they're trying to flip it and then say, well, once they confronted him, he became the aggressor, and they then have the defense of self-defense. Very, very hard to be able to prove that legally because they were the initial aggressor. And obviously, like they fear for their lives, it was the 3 of them. He was fearing for his life as they were chasing him down.
Yeah, so again, these are 2 cases that we're all watching very closely, and we do appreciate your insight today, Damian Jackson. Thank you so much for joining us. We appreciate that.
Hey, thank you for having me. You have a good evening on purpose.
Take care.